Welcome to our third lecture covering employee privacy issues. In our first two lectures, we had an introduction to the topic. We talked about the reasonable expectation of privacy and how important it is to the analysis of this case. We discussed governmental employment, which can raise constitutional issues under the Fourth Amendment, the Fifth Amendment, the 14th Amendment, and the penumbra of the Constitution. And then we move to statutory and common law issues, and they apply both to government employment and private sector employment. Now we're going to discuss some special issues relating to employer access to employee information, specifically off duty activities that the employee might have, testing and investigations, and employees' personal property. So let's begin. So, generally, an employer does have the right to regulate private activities, even if they occur off work, if they affect the employee's work performance, and arguably, even when they don't affect the employee's work performance, because it's usually left up to the employers to decide whether they affect or not. Now, of course, just because an employer can regulate something doesn't mean it's a good idea to regulate it. There are states that do have some laws that limit an employer's ability to regulate private activities. New York is one of those states. Activities outside of the workplace generally cannot be regulated nearly as much as it can in other states. Texas doesn't have that type of law. So, an employer can regulate drug use, tobacco use, alcohol use, can regulate people's weight, various recreational activities, for example, doing dangerous things like skydiving or bungee jumping or water skiing or scuba diving, or ATV activities, for example. Moonlighting, an employer can prohibit an employee from having other jobs, can regulate the relations that an employee might have with coworkers, competitors, customers, and any type of behavior that might reflect poorly upon the employer. For example, an employee who goes to gentlemen's clubs, that behavior might reflect poorly upon the employer, or an employee who uh, uh, engages in certain political activity that has a bad reputation, maybe uh, rioting or something along those lines. That could be an area where the employer could regulate that. And of course, the way employer regulates that is telling employees they shouldn't do that, and or dismissing or disciplining employees who do engage in that behavior. One issue that oftentimes come up is marital status discrimination. There is no federal protection in this area, but several states do provide marital status discrimination, meaning that an employer can't discriminate against someone because a person is single, because a person is married, because a person is divorced, or because a person is widowed, or because a person remarries after some period of a divorce or widowhood. Texas does not have that protection, and so there is no problem with an employer who chooses to discriminate based upon marital status. Just watch out for the sex plus claims in that situation, because if you're monitoring the marital status of your female employees but not your male employees, then that would be a sex plus situation, kind of like the Phillips case. Um, and also, even in states that have marital status discrimination protection, usually it doesn't apply to the specific person that the person is married to. So, for example, if I live in a state like New York, which has marital status protection, and I work for company ABC, and I happen to marry the owner of a competing business to ABC, then ABC would be free to dismiss me. I'm not an expert in New York law, but I would certainly think that ABC would be free to dismiss me because ABC isn't discriminating against me based upon my marital status, but based upon the particular person to whom I am married. And again, Texas generally does not regulate employer behavior in these areas. Uh, let's discuss some scenarios. So, Plano Hospital has informed all of its employees that it is going to prohibit use of tobacco by employees. Under these circumstances, the hospital would be free to enforce that policy because, again, Texas does not regulate this type of thing. If the hospital wants to regulate that, it certainly can. It's quite common for businesses to require employees to pay a premium if they happen to use tobacco products. In that situation, that would also be permitted in Texas and in many other states. Let's consider the second scenario. Mary works in a fitness center as a gym instructor. Recently, she's had some stress in her life, and so she started eating a lot of chocolate in the evening, and she's gained 14 pounds. Her manager says that she needs to lose the weight in order to be successful in her position. The customers or the clients in the salon expect to see toned person to be their instructor in those situations, to be a source of inspiration. Mary doesn't lose the weight and she's dismissed. Under those cases in Texas, again, she would be free, or the employer would be free to dismiss her, even though obviously chocolate is not a controlled substance. Let's consider this scenario. So, Bob and Mary live in Collin County, so we're talking about Texas. Bob works for Mary. Mary's a Republican, Bob's a Democrat. Actually, I changed the name. Let's make this Bob. Mary says, "Hey, you need to vote for the Republicans or I'm going to fire you or demote you or something." When Mary finds out that Bob, in fact, did vote for the Democrats, Mary demotes Bob. In this case, Mary's action is lawful. In my opinion, not wise, but lawful. It is okay for private employers. Now, of course, if this were a government entity, this would be illegal behavior to enter politics in, or to have politics be a factor in the situation. But amongst private companies, this would be lawful. Again, you could have a sex plus or a race plus situation. You can't be concerned about the politics of one category of your employees and not the politics of another. Same scenario, we're still in Texas. Both work for the same company. This time, Bob is the supervisor. Bob asks Mary about her living arrangement, who she lives with. Mary says it's none of your business, so Bob fires her. It doesn't really matter what Mary's living circumstances are. Again, there is no right to keep your living arrangements private from your employer. The employer is free to dismiss for that basis. Again, this goes back to the idea of at will employment. And Bob can fire Mary for any reason other than an unlawful reason, and there isn't an unlawful reason in this circumstance. Now, of course, if this is a case of sexual harassment where Bob is trying to date Mary and trying to find out if Mary has a significant other, there could be some issues along those lines. But this question in isolation does not present sexual harassment as an issue, and so this would be a lawful action on the part of Bob. Probably not that smart, but lawful. A related topic in this area is the European Union does have a lot of rules about data protection that do apply in lots of contexts and including the employment context. So be aware that this can run afoul of EU rules. And so an employer that is multinational needs to make sure that if it's going to monitor this stuff in the United States, it doesn't inadvertently do this monitoring of employees in other locations where there may be very different rules. And this may even require that the employer have different data systems to manage that data and to keep that data separated. Um, a private employer generally can engage in drug testing. We've talked about these four categories of drug testing before. You don't need to know the name of the statute that gives this right to private employers. But the first type is pre-hiring, pre-employment, and there are very few restrictions in this area. The ADA, for example, does not consider this a medical test. Then we have reasonable suspicion. This can be because a person appears to be intoxicated. Maybe they smell of alcohol or marijuana. Maybe their speech is slurred, or they are moving in an uncoordinated manner. Or it could be that they have been in an accident in a company vehicle, and it may be the requirements of the employer whenever there's an accident, even if the employee isn't to blame, to have a drug and alcohol test. In addition, employers can do random testing of employees to see what the level of drug use is and to address positives in that sense. I guess actually, post accident is separate from reasonable suspicion, so that's another category. Now, when the samples are collected, and usually urine is used for the collection of samples, especially for drugs, um, the privacy interest of the individual does need to be respected. If it's a practice to have the taking of the sample be viewed by uh, the another person, to have a person of that same gender view the taking of the sample, and certainly as much respect and courtesy that can be extended in this situation is a smart business idea. The Grossendorf case isn't something important for you to know, but just I'm offering it to you as an example that there really isn't a constitutional right to smoke a cigarette by an employee. In this case, Grossendorf was a firefighter, or at least beginning the process of being a firefighter. He wasn't allowed to smoke as a firefighter. You can kind of see why that would be the case. He took 3 puffs of a cigarette while on a lunch break once. That was discovered by the union, by the, I guess, the supervisor, and he was dismissed. He sued, saying, hey, he has a constitutional right to smoke. Well, no, he doesn't. The rule has a rational basis for enforcement because, we want to have firefighters who are in good health and they have good physical conditioning. And so it makes sense for firefighters not to be engaged in smoking. Yes, Gressendorf does have a liberty and a privacy interest, but it doesn't raise to the point of being a constitutionally protected fundamental right. And of course, we've seen this term before in earlier presentations. Federal government contractors and government grant recipients need to prohibit the use and possession of any controlled substance in the workplace. This is that Drug-Free Workplace Act. You don't need to know it, but that is a requirement. Now, most private employers, even those that are not federal contractors, don't want to have controlled substances in the workplace either, but they aren't required to post something to that effect. We've already discussed the ADA, and again, the ADA does not protect current users of illegal drugs. It doesn't even protect past users of illegal drugs who do not have a disability related to that. In other words, they are not addicted to the substance. It doesn't protect current users of alcohol who are not addicted to alcohol. Um, Again, like most states, Texas does give employers a lot of discretion in how they're going to drug and alcohol test employees or whether they're going to do that at all. So, generally speaking, there are relatively few limitations on those practices. Having said that, it's a good practice for employers to have very clearly defined policies and procedures about how it will proceed and to have your employees trained in that, because there can be tremendous morale implications if you don't do this in a smart way. There may not be any legal issues, but if half of your workforce is quitting or is dissatisfied with the working conditions, that does not lead to a productive work environment for your client. Let's consider this case, the Boris case. Again, it's not out of the Fifth Circuit. Is an employer justified in discharging an employee because she refused to submit to a drug test? And of course, in this particular case, the court said no, that the employer is not. The court found mandatory drug testing can be a violation of employees' right to privacy. Now, would that be what the Fifth Circuit, our court, says? Absolutely not. So, this decision, the Boris decision, does not apply in Texas. And I think it is a very safe bet to say will not apply in Texas in the foreseeable future. I definitely do not expect this to be the law that would apply in this state. I offer it to you just to give you a sample of how laws in other states can apply. One of the things that happens in a course like this is we focus on our state, and so it's easy to start assuming in your practice, well, this is the rule in Texas, so surely it's a rule everywhere. But it's good to always keep in mind that when you cross the Red River or the Sabine River, or you go into New Mexico or wherever, the rules can be quite a bit different. And so you do have to make sure that you independently research the law before assuming that the Texas rule applies elsewhere. Sometimes there's going to be the need for an employer to do investigations. It could be about sexual harassment. It could be about theft in the workplace. Under those circumstances, typically the HR department is involved. Sometimes the loss prevention department is involved. And it's important to have well established procedures that are followed conscientiously. It's important to have all the participants who are conducting the investigation know what those procedures are and understand why we have those procedures in effect so they can be sure that they're going to follow those procedures. Do we take statements? Do we not take statements? Do we record the interviews? Do we not record the interviews? Who has access to the files? What happens to the file after the conclusion of the case? And really, the risks here can be in gathering the data. What data is gathered? Who knows about the gathering of the data? Is it restricted to just people who have a need to know? The people who are conducting the investigation, the decision makers, and whomever is technically responsible for retrieving the data, or other people allowed to know? Usually, the best practice is to restrict who knows about the information to the extent possible. So these are the concerns that can come up in these cases. Um, we've already discussed interviews and why it's important when you are making hiring decisions, either with external candidates or internal candidates, that you think carefully about the interview questions that you're going to ask so you're not gathering data that you don't want to have and that you don't have a right to have. And of course, whatever information you gather, you need to make sure that you properly store that information. If it's no longer necessary, you may want to shred it. If it is information that you want to retain, you want to make sure that it's kept in a secure place that can be retrieved when it's necessary. An issue that comes up pretty often, and this is especially true in the last 20 or so years, is whose device is being used. Imagine that I'm working from my home during the pandemic. I'm probably using my own computer as I work on my company business. Let's say I store some files on my own computer. Who do those files belong to? My employer, who gave me the data and possibly the training to accomplish that work, and it may include trade secrets, customer lists, or other information. Or perhaps it belongs to me because, after all, it's on my computer. How can the employer be guaranteed access to that information? Let's say I quit. Well, how can the employer get that information that it may need or be entitled to? Um, how can that employer know that that information even exists? And what type of information is it on? Let's say I'm on a business trip and I use my personal cell phone to make some business calls. Again, there may be text messages or data about that call on my cell phone, but if it doesn't belong to the company, it presents hurdles for the company to get access to that. And this can extend to laptops and computers and tablets and cell phones and used to be pagers, and we'll see that in a couple of minutes. And so, who owns the data? Who has access to the data? All of that can get to be quite confusing. Administrative password abuse. This is something that I actually dealt with in my former life as a person who was giving legal advice to clients. And in this situation, there was a computer person in a particular department who had access to basically everybody's computer because he or she had the magic password that gained access. And he abused that. He or she used that information for his or her own curiosity to find out. I think the person was looking to see whether the people were paid. Um, he or she felt that he or she was being underpaid, perhaps. Anyway, that type of thing can happen. And of course, in that case, that particular employee ultimately was dismissed for that behavior. but you can see how private information of employees was accessed. And let's say that particular person had used that information to gossip with other people to say, hey, you don't know this, but the person who does the same work as you do earns $2 more an hour or something along those lines. And so you have to be careful that the person you put in positions of trust are worthy of that trust. And you also need to have checks in place to make sure that the person is not abusing those checks. So now we've completed talking about the special issues relating to the employment privacy issues. Let's begin by starting the discussion of employee monitoring, specifically monitoring of telephones, emails, computers, also medical records, investigations, and polygraphs. So employer monitoring has existed. When I say employer monitoring, I mean monitoring by employers. Employer monitoring has been going on since time immemorial. On the assembly lines, the supervisors would walk up and down, making sure everybody was doing the job that they were supposed to do. There would be a quality assurance people inspecting the work that was completed. And so this is not a new concept. It's just that nowadays the tools that employers have to do it are oftentimes technological and more sophisticated, and many times they can feel more intrusive. In some sense, they're more effective at surveillance because they can gather data and let the employer know exactly how efficient a person is in a way that a supervisor walking up and down the halls might not have been able to achieve. There are obviously concerns about this. The idea of Big Brother watching you, it can feel intrusive, it can feel disrespectful, and so there are lots of negatives associated with it. It can have bad impact upon morale. On the positive side, it can motivate employees to be more efficient in their work lives. It can also permit employers to reward employees who are more efficient because now there's a way to measure the efficiency when there may not have been that possibility before. So there's advantages and disadvantages, and certainly a sophisticated employer is going to consider all of these issues as well as its corporate culture to see if what type of monitoring, if any, is appropriate. Um, Productivity measurements are one way that can be very useful, and these can be keystroke monitoring. If I'm a typist and I'm not hitting the keyboard with my fingers, then it probably means I'm not doing my job. It's possible I'll spend a few minutes reading the material that I'm supposed to be typing. Maybe that's going to make me a quicker typist. But if I have an extended period of time where I'm not typing, obviously I'm not being productive in that situation. So a device that monitors my number of keystrokes in an hour could be a good measurement. On the other hand, if I do a lot of keystrokes, but a lot of my keystrokes are to correct the errors that I did because I was typing too fast, then yeah, I might look very productive because I have a high number of keystrokes per minute. But another person who has fewer number of keystrokes but has more accuracy and therefore doesn't have to go back and correct a lot of the work, that person, even though their productivity appears to be lower, is actually more productive. So productivity measurements are not always foolproof. One issue that comes up is our workforce has changed. It used to be that you clocked in, you worked during the day, you clocked out, and from the time you clocked out, you weren't thinking about work. There was nothing you needed to do related to work. Nowadays, though, oftentimes work follows you home. You take it home with you. You might be checking your emails. You might be taking calls. You might have to resolve a matter in a different time zone. You might be traveling. And so, in that situation, you might kind of perpetually be on. And so, when can the employee monitor you? Excuse me, the employer monitor you? Well, if you're an hourly person, you really shouldn't be working when you're not clocked in, although sometimes that can be clocking in at unusual hours. But if you're in management, in some sense, all of your time is clocked in time. But certainly, nobody wants to be measured for productivity 24/7. So, deciding when the productivity measurement should stop needs to be part of that policy and has to be carefully thought through. There can be other technologies that can affect employer monitoring. I imagine that, for example, UPS probably has some kind of GPS system on its trucks. That would help it if one of its trucks gets hijacked or taken. It would also let the company know if a UPS delivery person goes off of his or her designated route, maybe to do some personal business or something like that. And so they could address that issue at that point. And then there are other tools that can be used to see if the employee is where he or she is supposed to be. Um, and for example, a biometric ID could be a retinal scan or it could be a fingerprint. Those would be examples of examples. RFIDs are those little codes that can be put on things. Again, a person could be issued a badge that would allow them to badge into certain places, and there would be a record of where they go and when they arrived in a place and when they not arrived in a place. I'll give you an example of how this can work. I once worked in a place where a secretary or the secretaries would clock in and clock out, but they would actually write their time on the timesheet in a central place. But in order to get into this place where they recorded their time into our particular workspace, they had to badge in and badge out. And so what would happen is a person would badge in and then they would go to this place where they would write their time. It was on the honor system, but it became clear that one person was not accurately recording her time. She was entitled to have an hour for lunch, but she was taking more like an hour and a half. So she would record that she got back from lunch at, say 1:03 p.m. But she didn't use her badge to enter until, 1:27 p.m. And it's possible that sometimes she may have followed somebody in, and because people didn't always use their badge in this particular workplace, sometimes they would follow somebody in using that person's badge number. So it's possible on that occasion she actually followed somebody in, arrived at 1:03, signed in, and then had a need to leave that work area to go somewhere else. And so her 1:27 badge in wasn't from lunch, but was from another purpose. But it happened so many times that it became very clear that she was, in fact, not recording her time correctly, and her employment ended at that time. So these measurements can be used in lots of different ways. We're all familiar with social media. Here's a definition, though, that may be helpful. User created content, including text, video, audio, and other multimedia, and this is which is published on a shared environment, some Facebook, Instagram, uh, Twitter, those types of things are social media. And many times employers have policies about what their employees can and cannot post on social media. Because again, it can reflect poorly upon the particular business. We're going to talk about the city of Ontario and Quan in a few minutes. One of the things that we'll take away from that is that there is a balance between the privacy interests of the individual and the business interests of the employer. Generally speaking, the business justification wins in these cases. The employer, especially when it's not a public employer, as we have in the Quan case, but when it's a private employer, especially if the employer has made it very clear via notice to the employee, then those monitoring that happens is going to be upheld. But one of the big reasons why the notice works is that it reduces that reasonable expectation of privacy. As far as I'm confident that Texas does not have a statute that limits compelled access to passwords. Sometimes employers will say, give me your password to your Facebook account or to your Twitter account, or more so Facebook account, so we can see, or friend me on Facebook so I can see what you're posting on Facebook. If there's a concern that it may not be appropriate, or it may create a bad reputation for you and therefore for your employer in the community. Even states that limit the requirement that employees give up passwords will usually have an exception if there's an investigation. For example, let's say there's a sexual harassment investigation and the alleged victim is saying, well, there's stuff on Bob's Facebook that will support the allegations that I'm making against Bob. And then the company goes to Bob and says, let's see your Facebook. That seems like a very reasonable course of action, certainly something that would be permitted in Texas. Here's the Quan case. As we start here, this is the city of Ontario, so we're talking about a public employer. And in fact, this was a SWAT team, so I guess it was a police department. This case was from a while ago. The SWAT members of the team, and Mr. Quan was one of them, were given pagers, and these pagers did allow text messages to be sent. And as you can imagine, if you're on a SWAT team, sometimes you had to have a lot of hanging around time as the situation is tense, but you may just be waiting for things to develop. And the informal policy in this city was that the employees, that the SWAT team members were allowed to use their pagers for personal emails as long as they paid any fees that might accumulate from all these extra text messages. And that's what Mr. Quan and several of his colleagues did. Well, it ends up that it came to light that Mr. Quan and others had explicit sexual content that they were sending out on these pagers. Once the city became aware of that, they were subject to discipline. Well, Quan said, "Well, I have a constitutional right to privacy in this matter, especially since I was told that I would be allowed to do this." And so the case ultimately went up to the Supreme Court. And the Supreme Court disagreed with Mr. Quan and said that the search of the text messages was reasonable. Um, Again, the court said it may not be reasonable in every single situation, and we're not going to make a blanket rule because guess what? In 2010, we're smart enough to know technology is constantly changing. And what technology exists today, the options with it and the social values that we have may be different in the future. Um, the reason that the messages were perceived of as reasonable is that there was a legitimate work-related reason to look at these messages, and it wasn't excessive in scope. You don't need to know the name of this course, but I wanted to offer this to you to show even when there's public employment involved, the public employer can still check things like this. So at this point, we're going to end our presentation. If you have any questions, as always, please feel free to pop into my office hours. It was a pleasure having you in this session, and I hope you have a wonderful day. Take care.